All right, Mr. Dolezal, would you please begin the announcements?
Yes, John Dozel for the department.
Kim Coffey, Belong Adoption Specialist.
Anna Swallow, attorney ad litem for ACE.
Amy Harding, Hilton Tree Casa Supervisor, Guardian ad litem for the child.
Judy Hartnett, Guardian ad litem, CASA volunteer for the child.
We're here today for a permanency review. I read the reports. Looks like permanency goal remains relative adoption. Child still placed with family in Kerrville. Valdez's placement is safe and appropriate, meeting his needs and in his best interest to continue, Ms. Coffey.
Yes, Judge.
And is he up to date on everything now? I know he had a dental back in March, but everything's up to date.
Yes, his dental was March 19th, and he went yesterday to get a couple cavities filled, so he is up to date.
Okay. And then no special services?
No, Judge.
And since our last hearing, no other family members have come forward, and he's bonded to the caregivers?
Correct.
Okay. And it looks like the issues with the risk eval are done, and now we're just waiting on some paperwork to be finalized.
Right now, so yesterday there was a joint interview with SJRC. Today is Mr. Valdez, and then on the 25th is Mrs. Valdez. They still have to turn in some things such as like a floor plan, their marriage license, proof of citizenship, and they have a few more trainings to do, but they are making some progress. So we are getting closer. I talked to Holly Cox with SJRC this morning, and she said that they are looking for the family to get licensed next month in May.
Okay. But the risk assessment that we had been talking about back in November, all that's done, correct?
Correct, yes.
Okay. Mr. Dolezal, do you have any questions for Ms. Coffey?
No, I think you covered it all, Your Honor.
Okay. Ms. Swallow?
No questions, Judge.
What are you thinking about things?
I think they're going well. I was able to visit in the home yesterday, and I visited both boys. So Ace and his younger brother, that's also his goal is to be adopted with Ace. And everything is moving along. You know, I don't know why becoming licensed lately is so difficult for agencies and families. I'm sure if I dug deeper, I could figure it out. But the Valdezes are doing everything that they can. So I think that, by the end of May, getting their license will time out perfectly because the companion case, that final trial was March 6th. So we need 90 days from that date anyway. So I think we're in a good place. I advocate that the placement continue, and I believe it to be in his best interest.
Thank you. Ms. Hartnett?
Yes, I agree with Ms. Swalwell. I visited the family on Monday. They seem a bit frustrated on what classes they have to do and what's required of them. I don't think the communication is always the best.
What do you propose anything in order to bridge that gap, or do you think it's something we just have to wade through until we're done?
I don't know enough about it, but every time I ask about the classes, they say they're making progress, and it seems like that they can't get the classes they need, or they can't sign up for them. They're frustrated, and I am, because I don't understand enough about it. I don't know if Ms. Coffey has more information than I do on that, but it seems like they really want to do it, and they try, but they don't seem to make as much progress as they should be making.
Ms. Coffey, you think there's any solution to that?
Judge, I know that they were going to do a training that was a virtual training a couple weeks ago. It was on a Wednesday night. They logged on, and the trainer was not there. And the trainer said that she did not see them in the training, so she just left and went home. So they had to reschedule that one. I know that they were having issues with trying to get the certificates uploaded because they were trying to do it by phone. I think now that they're doing it on a tablet or Mr. Valdez's work laptop, they're making some more progress with that. I think, time is a lot for them as well. They've got 4 kids in the home. They're very active in their church. I think they're trying to do the best that they can. I do believe there has been some communication issues between them and the licensing agency. However, I am copied on a lot of the emails, and SJRC has been listing exactly what they need to do, what trainings need to be completed. I think just at the beginning of this process, it wasn't very clear, but I think they are being clear now. I think right now it's just a matter of the family getting it done.
Okay. Well, Ms. Coffey, I don't know if you have contact with the trainers, but there's anything you can do to make sure that, if somebody's not in the room or whatever's happening, that they have phone numbers and they can just give each other a call and say, hey, where are you? We need to get going on this. So hopefully we won't have that issue again. Okay. Then for the purpose of the permanency review after final order, the court finds the permanency goal relative adoption is in ACE's best interest. Court finds that his placement is safe and appropriate, meeting his needs. It is best interest to continue. He's up to date on all of his checkups. He's not receiving any special services. This is the least restricted placement available, and he has bonded to the caregiver. Since our last hearing, no other family members have come forward. The only known barrier to adoption is just waiting on the final licensing paperwork and some classes and training. Court finds that Belong has made reasonable efforts by making sure the risk assessment was completed and then continuing to work on the licensing process. Our next hearing, how about September 18th?
Sounds good.
Does that sound better?
Yes.
We don't have to go back in time.
Is that at 9:30, Judge?
That will be at 10:30.
Okay, thank you.
So September 18th, 2024 at 10:30.
No objection, Your Honor.
With that, Mr. Dolezal, will you please begin the announcements?
Yes, John Dozel for the department.
Lucinda Mance for the child.
Cecilia Hellrung on behalf of the mother. Ms. Ferguson, if you could please unmute and announce.
Elizabeth Ferguson, mother of child.
Charles Weatherby, standing in for Maureen Yanis, who represents Mr. Newman, the father of the child. Would you announce, please, Mr. Newman?
Yes, sir. Anthony Newman, father of the child.
Cassandra Glass, permanency specialist.
Lindsay Ligon, Belong permanency supervisor.
Goldie Rabson, Hill Country Casa, guardian ad litem for the child.
Okay, thank you. We're here today for a final trial. My understanding is the department has filed a motion to retain. Has everybody received a copy of that?
Yes, Your Honor.
Yes, Judge.
Are there any?
I believe Ms. Yanis has. I haven't seen it, but
Okay.
she's agreeable with it.
All right, so there's no objection.
No
That's
objection,
great.
Your Honor. We had a meeting about it and all the parties were aware, and I believe there was an agreement at the time.
Okay.
No
Then,
objection.
thank
No
you, Ms.
objection,
Nance.
Your Honor.
Thank you, Mr. Weatherby. Ms. Glass, we're going to need to do, I think we're going to need to do a permanency hearing if we extend the case today. Mr. Dolezal, you're wanting to extend under 401B, correct?
Yes, Your Honor. And I hope I pronounced her name correctly. Calestina is wanting to move in with her father, but the department feels that it's essential that father do some additional things before that is in the best interest of the minor child. So we believe the extraordinary circumstances are to give the parents additional time to complete services.
Okay. Ms. Glass, you believe that it's in the best interest of Calestina to have the case extended so that the parties can, specifically Mr. Newman, can continue working some services?
Yes, sir. Callie has reported that she does want to finish the school year at her current placement, just mostly because she's been doing phenomenal. She's inducted into the National Honor Society. And Mr. Newman just needs to follow up with appropriate housing. He does have a friend. We just need to do a walkthrough of the house and run background checks on the friend. I have spoken to Callie about how she feels about moving in with his friend and Mr. Newman, and Callie is okay with it. She's excited to have the opportunity to move in with her father.
Okay, very good. And while we're talking about Callie, she's up to date on all of her checkups.
Yes, sir.
Her placement's safe and appropriate and meeting her needs.
Yes, sir.
Is her psychotropic medication review up to date?
I believe so, sir.
And her educational needs are being met. Obviously, if she's being inducted into the National Honor Society, that's really great. No concerns with her schooling.
No, sir, none.
And there's no Indian child heritage in this case. Is that correct?
No, sir.
And her permanency goal is still reunification with the father.
Yes, sir.
And this is the least restricted placement that she's in.
Yes.
All right. We still doing visitations with Ms. Ferguson once a month?
Ms. Ferguson has not expressed wanting to restart those visits back up with Callie. She knows to reach out to, there is a new caseworker effective yesterday taking over the case. So she knows to contact that caseworker when she wants the visits to resume. Callie is ready for them to resume with Ms. Ferguson, but she understands that her mom has to be ready as well to start working on their relationship.
Okay. Are both parents in compliance?
Mr. Newman is. I did speak with Ms. Ferguson's outpatient treatment facility. She's with Hop and Associates in Colorado. For the most part, she is in compliant. However, there are some, she's not as, she's about 50-50 with her group sessions. And she has tested positive for marijuana, and that goes against what the outpatient treatment is.
Okay.
She did, however, complete her parenting class.
So would you classify her as not being in compliance at this time?
Not compliant with her treatment, no, sir.
And Mr. Newman is in compliance?
Yes, sir. He has completed all of his services. We did discuss about having him engage with Chosen since Kelly is getting closer to being returned to his care. So that referral was sent out. They do have his contact number to be reaching out to schedule that. And I think we have a staffing with Chosen on Friday to discuss the case.
Okay.
Could
Did
you,
Kali get her state ID?
That we're still waiting on because we were so close to having her move from Sugarland to Kerrville. So we decided to wait until she's moved and settled to where she's going to be to get that state ID so she doesn't have to go through the trouble of getting it renewed.
Okay.
I'm sorry, could you repeat my computer or my phone froze up? Could you repeat that before the state ID? What was said?
I think we were just talking about you being in compliance and that she's going to be moving soon.
Oh, okay. Okay. Thank you, Your Honor.
You're welcome. Did Callie have her life skill class?
I know she completed PALS. I am following up with them to make sure that she did complete it in its entirety. I think there might have been one class not completed.
All right. As of today, would it be safe to return Callie to either parent?
Not until Mr. Newman has appropriate housing.
And as of today, has either parent fully addressed all of the concerns that brought Callie into care?
No, sir.
Do you believe that Mr. Newman has made a good faith effort to successfully complete his service plan?
Yes, sir.
You believe he needs additional time?
Yes.
And the permanency goal is reunification. So at the completion of a service plan, belongs intent to reunify with Mr. Newman?
Yes, sir.
All right. Mr. Dolezal, any questions?
No, well, just visitation, Your Honor. Are the parents visiting with the child?
Mr. Newman actually had a weekend visit this past weekend. He reported it went great. I talked to Callie last night. She said it went great and she had a really good time with him.
And then, Your Honor, just to clarify, you had asked about Indian heritage, and the question was, there's no Indian heritage, correct? And the answer was no, sir. I think it should be, what's the correct answer, Ms. Glass?
There is no Indian heritage.
All right, thank you. Just so the record's clear.
Sure.
No further questions.
Okay. Ms. Horan.
Yes. Now, you testified that Ms. Ferguson has completed her parenting. She is actively engaged in treatment, but not doing her groups as much as she should. And she did test positive for marijuana, correct?
Yes, and that if you need the date for the last one, it was a hair follicle NUA. The results I got back were from March 22nd. I did send her, I believe, last week, and I haven't gotten those results back yet.
Okay. Now, is she aware that that could impede her ability to have unsupervised contact with a child?
Yes, and from discussing with her, she's not ready to have any visits with Callie yet.
So now, is she following through with her mental health issues?
In her individual sessions, yes.
Okay. So is she doing counseling with a substance abuse or just regular counseling or both?
With what they described to me is that they do, it is a substance abuse, but also she explained that they do some CBT therapy.
Okay. Now with that program, is that an inpatient or outpatient program?
Outpatient.
Okay. Is she does she have stable housing at this point?
Yes, she reports to me she does.
Okay. Do you know where she's residing? I don't need the address, just in an apartment, in a house?
In an apartment.
Okay. And is she employed right now, or is she still looking?
Well, she hasn't provided me with any check stubs. She did report to me that she is caring for her partner.
Okay. Okay. Now, what other services, or is that pretty much everything you've asked her to do?
I believe that was everything remaining from when I took over the case.
Okay. Nothing further, Your Honor. Thank you.
Mr. Weatherby?
No questions, Your Honor.
Ms. Mance?
Yes. Are you aware that Callie would like an opportunity to meet and visit with Dad's potential roommate prior to approving this?
Last night she did not report that to me, but it's understandable.
And you agree this would be in her best interest if she did so?
Yes, ma'am.
All right. Thank you. I'll pass, Judge.
Anything else, Mr. Dolzer?
Nothing, Your Honor. We rest.
Okay. Anybody else have anything they want to present other than just reports?
No, Your Honor.
All right. Ms. Mance, you feel good about everything so far?
Yes, I had a Zoom visit with Callie last night. She's just amazing. I'm so thrilled that she's such a good student, and I really look forward to meeting her in person in school as soon as school is over and she moves up to the Kerrville area. I did ask her what her thoughts were about her dad and the potential roommate situation, which is a male family friend. She said she didn't know this person, but that she would like an opportunity to meet and visit with him, even if over Zoom. I think that's a very reasonable request, and it's definitely in her best interest. It does give me a little bit of pause. A young teenage girl living, I'm just going to be honest, living in a household with another adult male that she is not familiar with. It may be totally appropriate. It may be a great living arrangement, but I certainly think that it needs to be thoroughly vetted and that she needs to feel comfortable with that living arrangement. But she's doing awesome. I'm so proud of her and really can't wait to meet her. That's all I have to report, Judge. Oh, and she did tell me that she and Dad had an amazing visit. They went fishing. She caught a fish, or maybe her dad did, but it just sounds like he's an awesome dad and will be a great primary caretaker for her.
Wonderful. I'm glad to hear it. Ms. Rapson?
CASA believes that this permanency goal is in Callie's best interest. She is a great student and a really cool girl, and she and Mr. Newman's relationship is quickly blossoming. We look forward to when she can be placed with him, but we 100% agree that we need to be very careful about where Mr. Newman is living, make sure that Callie feels comfortable, and that situation is totally appropriate.
Wonderful. Thank you. All right, then, for the final trial, the court has heard the department's motion to retain under 263-401B. Court finds that all parties are in agreement and that it is in the best interest of the child. And the court finds that extraordinary circumstances necessitate the child remaining in the temporary management conservatorship of the department, and continuing the appointment of the department as temporary management conservator is in the best interest of the child. The court will retain the suit on the court's docket for a period not to exceed 180 days. The dismissal date is going to be December 7th, 2024. December 7th, 2024. New permanency goal, or excuse me, next permanency hearing is going to be July 17th, 2024 at 2 p.m. July 17th, 2024 at 2 p.m. And the final trial is now reset to October 2nd, 2024 at 11 a.m. October 2nd, 2024 at 11 a.m. Court further finds that and has considered that Mr. Newman has made a good faith effort to successfully complete his program and needs additional time. And then on the completion of the service plan, court intends to return the child to them. Regarding the permanency review, court finds that Callie's placement is safe and appropriate, meeting her needs and in her best interest to remain there. Permanency goal is family reunification with Mr. Newman. There is no Indian child heritage in this suit. Callie is up to date on her checkups. She's receiving therapy and her psychotropic reviews are up to date. Her behaviors are good. Court finds her educational needs are being met, and that she has been participating in PALS. Court finds that the current visitation plan is appropriate and that visitations will resume with the mother, and she's at a point where that she finds them to be appropriate. This child has been able to express her concerns that she wants to have visitations with mother, but they're not in her best interest at this time. Court finds that Mr. Newman is in compliance with his family plan of service. Court finds that Ms. Ferguson is not in compliance with her family plan of service, but sounds like you're trying to get there, Ms. Ferguson, so that's good. Court finds that as of today, it's not safe to return the child to either parent, nor has either parent fully addressed all of the concerns at this time, and it's in Callie's best interest to remain in the temporary managing conservatorship of the department / belong. Court finds our court sets the next hearing for July 17th, 2024 at 2 p.m. So I already gave you that date. Mr. Newman, keep up the good work. Sounds like things are going really great, and I really appreciate all the hard work you've done moving forward in this case. And then Ms. Ferguson, just keep moving along and trying to make progress, and hopefully we'll have some better reports when we come back in July. I have to admonish you both. We've just had an extension in this case. Normally you get 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. Certain cases get extended. However, there's still a timeline and it will run out. And although things seem to be going pretty well right now, Mr. Newman, just continue to work forward, move forward, knowing that we're still in this case. Okay. All right. Thank you all for your time and your service. If nothing further, all parties are excused. Good luck to you.
Thank you.
Thank you, Your Honor.
I see we don't have either parent here. Are we expecting them?
Your Honor, the father is not, he's somewhere in Louisiana, and I haven't had a chance to find out anything about where he might be. I'd appreciate any information anybody has that would narrow the search.
Oh, I think Charlie's on for the next one. We're doing Castro right now, right?
Yes, Mr. Weatherby, you'll be on the next case. I'm going to put you back in the waiting room.
But no, Your Honor, I don't expect my client today.
Mr. Costa?
Your Honor, let me reach out to her, but I'm fine to proceed.
Okay. Any announcements?
Yes, John Dozel for the department.
Cindy Harris, permanency specialist.
Lindsay Ligon, belong permanency supervisor.
Irene Augusta, attorney ad litem, appointed to represent the respondent, Mother Blake Kuykendall. She's not present, Your Honor, but I'm ready to proceed.
Kathleen Savage, attorney for the respondent father, Mr. Castro. I'm ready, Your Honor.
Jennifer Harris, attorney ad litem for the child. I'm ready.
Goldie Rabson, Hill Country Casa, guardian ad litem for the child.
All right, Ms. Harris, after reviewing the reports, looks like Arrow is currently in a placement in Guadalupe County. Is that placement safe and appropriate, meeting his needs?
Yes, it is.
Is it in his best interest to remain in that placement?
Yes.
Have the parents given you any indication if there's Indian child heritage in this case?
No.
Is this placement the least restrictive placement available?
Yes.
And Arrow's caught up on all of his checkups, doesn't need a dental yet, and looks like the worst thing that's happening is some lactose intolerance.
Yes, other than that, he's doing well.
Any other developmental concerns?
He was seen by a developmental specialist, so he'll be receiving services.
The parties were able to hold a family group conference. Did both parents participate?
Yes, both parents were present.
All right. And you were able to create family plans of service that are nearly tailored to address the concerns that brought Arrow into care?
Yes.
And did the parents have an opportunity to review those plans and sign them?
They have reviewed them, but I have not obtained their signature on the family plans.
So they both have a copy?
Yes, they do.
And the family plans of service were filed with the court?
Yes.
And you believe those family plans of service are in Arrow's best interest?
Yes, I do.
You asking the court to make them orders of the court today?
Yes.
Have you had conversations with the parents about what's expected of them moving forward?
Yes, I have.
Are they cooperating with you?
Yes, they are.
Are they visiting?
Yes, they have been attending their visitations.
Are the visitations appropriate?
Yes, they are.
Are you asking for any changes today to the visitation schedule?
As of now, no.
What specific services are you asking the parents to do moving forward?
I'm asking them to continue with the services that they are currently engaged in. And then most importantly is maintaining the sobriety for both parents.
What services are they participating in right now? Just a brief list of the main ones.
They are currently both engaging in individual therapy. They have registered for a Parents as Teachers program through SGRC, and they're on the wait list for that. They are submitting 2 weekly random drug testing through UAs and 90-day hair follicles. I am asking that both parents don't alter their hair in any way. That has been an issue with Mr. Castro not having sufficient hair to provide for hair follicles. Ms. Kuykendall has had her hair bleached. There's issues with parents attending their UAs, which we kind of talked about at the family group conference, and I think we've agreed that I will create an appointment for them, and then they can either attend that appointment or change it, but make sure that they're attending or submitting to the UA within the given time frame. They both have supervised weekly 3-hour visits. And they're both still attending MHTD in Kerrville for mental health services as well.
Okay. You asking for any other orders today?
No, that would be it.
Okay. Mr. Dolezal, any questions for Ms. Harris?
No, Your Honor.
Ms. Acosta?
Yes, Your Honor, thank you. Ms. Harris, with regard to the drug testing, how long do they have to reschedule it? If they do.
I usually give them, I will send them, if I send them Monday morning, I give them until the end of the next day, so the end of Tuesday, to submit to that UA.
Okay, and the facility where you're sending the referral, do they keep it open for the parents to reschedule it at the end of the following day if possible? Or will they have any issues with that?
It depends on the availability of the testing lab. the parents will have to call and see what is available for them.
Okay. Do you know how long it's going to take for the Parents as Teachers program to begin?
They are on a waiting list, so it would just depend. I believe there is a 6-week wait right now.
There's a 6-week wait right now?
I believe so, yes.
Have you been receiving therapy notes from their therapists?
Ms. Consult just started through Mindful Innovations on April 12th, so she will be attending once a week virtual sessions.
Okay, and will you be receiving those notes after they're submitted?
Yes.
All right. How are the visits going?
The visits so far have been going well. The parents are both very engaging.
Okay. Is there anything that they need to do differently or anything else that they need to do to remain in compliance with their service plan?
As of now, it would just be the drug test, just ensuring that they're showing up within the given time frame and maintaining sobriety.
All right. Thank you. I'll pass the witness.
Ms. Savage?
Are there any referrals that still need to be sent out for Mr. Castro?
No, all the referrals have been sent out for Mr. Castro.
And if you obtain any notes from any service providers, will you be able to provide those to me?
Yes, I can.
As well as all drug test results?
Yes, I can.
I will pass the witness, Your Honor.
Ms. Harris?
Do you have any concerns with the recent drug test for the parents?
Yes, I do. Both parents recently submitted to a UA. It was on April 5th. Both of their results were negative, however, they were diluted results. I also received lab results for a hair follicle that Mr. Castro completed through probation.
I'm going to object to hearsay, Your Honor.
Sustained.
Oh, have you had a chance to speak with his probation officer?
Yes.
I'm not asking what she said, Your Honor. I'm just asking if she's had a chance to speak with her.
You can answer the question on whether or not you've had a chance to speak with her. Just don't tell me what she said yet.
Yes.
You have concerns about drug use after speaking with the probation officer?
Yes.
How long have you been working with this family on drug concerns?
Since May of 2023.
Aren't parents usually given till the end of the day to complete requested drug tests?
Yes.
If there's concerns with these parents altering results for drug tests, why are they being given more time than other families?
Initially, they were given more time due to the ability to set up the appointments with the testing lab. They are given until the next day. However, there still continues to be delays.
Is it possible for Belong to be able to schedule a drug test for a parent by 10 a.m. and let the parents know that they have until 5 to take it?
Yes.
After speaking with the probation officer, are there concerns about whether Mr. Castro is in compliance?
Yes, there are concerns.
And Ms. Kuykendall was not doing any services as of January. What specifically has she just started recently?
Your Honor, I'm object to this line of questioning as a status hearing, and this is Arrow's case. If we're talking about stuff that happened in January, his case didn't even start back then.
I would join in with that objection, Your Honor.
Your Honor, I'll withdraw the question.
Sustained. You have any other questions?
Just one, Your Honor. Do you think it's appropriate for the parents to have clean drug tests in order to have visits with their child?
Yes, I do.
No further questions.
Anybody have any other witnesses?
No, Your Honor. Department rests.
No, Your Honor.
No, Judge.
Ms. Harris?
No other questions, Judge.
What are your thoughts on things?
Your Honor, I understand that this is just a status hearing, but I think everybody here is well aware we've been working with this family for a very long time and multiple children, and we're still having problems with drug tests. I think that the parents need to be ordered to have a nail and a hair test done today by end of day. I think that they need to have testing that is done end of day for their regular drug testing. I think that any missed test, any dilute tests, any positive tests should result in the suspension of visitation until both parents submit to 2 clean drug tests. The drug of choice in this case is methamphetamines, and we're talking about an infant that was exposed prenatally and also is all now being held by parents during the full length of the visit that could be exposing the child to further methamphetamine exposure. So I think that there need to be 2 clean drug tests before there are any visits, and that includes dilutes and mist. The parents have mentioned that they would like for the baby to be vaccinated and stay up to date on all the vaccines. They are the parents. I think that's an appropriate request, and I think that should be done. Other than that, his needs are being met. Placement is on top of everything. And
what was the last thing you said needs to be done?
Vaccines.
Vaccines. Are the parents opposed to the vaccines?
No, I believe the parents want the vaccines, was my understanding from their most recent visit. And they may have already been scheduled. I just want to make sure that it's in there.
Okay. Miss Rapson?
CASA is aligned with the attorney ad litem's requests regarding the drug testing. Regarding Arrow, I understand that he is having an appointment with a craniologist. It's possible that he's going to need to be fitted for a helmet. So that is coming up, I believe, on April 25th. Otherwise, we believe that his current placement is in his best interest, and we do believe that that Arrow should be vaccinated at the parent's request. Thank you.
Okay, thank you.
Your Honor, just a response to the requested modified visitation, I would ask that request be denied. There's not a formal motion on file. The parents weren't noticed of that request. These parents are engaged. Obviously, drug issue is a concern, but all their visitations have always been appropriate with both children. There's never been any sign that they've shown up to visits high or under the influence in any way, and they're supervised by the department. So if they ever felt there was an actual safety concern, they could end the visit there. So I would ask that request not be granted today.
And Your Honor, I would join in Ms. Savage's statements regarding the visits. We're at a status hearing. These parents are continuing to work services, and I believe that it's the visits as they are right now are appropriate.
All right, thank you. For the purpose of the status hearing, court finds there's no alien child heritage in this suit. Placement for the child is safe and appropriate, meeting his needs and in his best interest to continue. Court finds that Arrow is up to date on all of his checkups. Does not yet need a dental, and that his GI issues, lactose intolerance, are being appropriately addressed. Court finds he has also been seen by a developmental specialist and will be receiving services for that, as well as a craniologist. Court finds the parties were able to hold a family group conference, and the parents participated in creation of plans that are narrowly tailored to address the concerns that brought Arrow into care. Court finds that the parents were given copies of the family plan of service and they reviewed it, but court finds that they have not yet returned their signatures. Court takes judicial notice that the family plans of service are on file and finds that they're in the best interest of the children and makes the family plans of service orders of the court. Considering the circumstances of this case at this time, the court's going to find that it's still in the best interest to defer child support and medical support at this time. The drug issue is definitely real in this case and real with these parents. Got significant history with them. So I agree that without prior notice, changing everything as of today is probably not the route I want to go. However, I do agree with Ms. Harris that we need to get serious about the drug issues now, not when we come back for our initial permanency hearing in July. So I am going to grant the request to have them do a hair follicle today by 5. No altering of the hair. That's part of the order. They can't do anything to their hair other than wear it on their head to a test and get tested by 5 o'clock today. And I want the results of that hair follicle distributed to all the parties. If the parents don't want to comply with drug testing, or if we're getting dilutes, or we're getting positives, or they're missing anything that can be considered a failure to comply with testing, then they're not going to continue to get these 3-hour-a-week visits that other parents don't get. That's a concern, a safety concern. If they're still using methamphetamine, then it's not safe for them to be around an infant for 3 hours. It's not the way we do things here. So they can keep their 3 hours a week unless this continues to be an issue. If any of these issues with the drug testing persist, I see that as a safety concern, and I'm going to order Belong to reduce the visitation to 1 hour twice a month supervised. We're not going to get anywhere in this case if these parents aren't serious about their drug use and the drug testing. So we're going to address safety concerns. We're going to address safety concerns. I'm going to order for Arrow to be vaccinated if that's not already set up. Our next hearing is July 17th, 2024 at 1:30. July 17th, 2024 at 1:30. That's it, Mosh. Yes.
My request about a nail test, because they're having concerns about hair altering. Can we get that order today as well?
You wanted them to have a hair and nail test today?
Yes, Judge.
Okay. I think considering the issues we've had before with testing, that's reasonable. So I'll order both to be done today.
And my other request was that they be required, their drug testing being same-day drug testing instead of giving 24 hours notice, or more, really.
Granted. It doesn't do us any good for them to have 24 hours.
I would just request, and if that is the order, then Belong needs to provide the parents notice no later than 9 a.m. that morning of the drug test request. Them sending at noon and then expecting them to get there at 5 isn't reasonable.
I agree,
think that's
Judge.
fair. Yeah, let's do away with the 24-hour requirement. It needs to be same day, and they need to have the request by 9 a.m., Ms. Harris.
And Your Honor, with regard to the nail test today, can we also make that contingent upon Belong being able to find somewhere to do a nail test today?
Well, I mean, I think it has to be, but here's what I don't want. I don't want the parents using the fact that Ms. Harris has to find something today and it takes a little while to say they didn't get sufficient notice. We need to try to get that test done today because their last test was a UA and it was diluted. So we really don't know where they are with things. And we need to figure it out. I want to know how serious they are about this case, too. I want to know how hard they're willing to work. Okay, I have to admonish the parents. The state of Texas gives parents in CPS cases 12 months to demonstrate they can provide a safe, stable, violence, and drug-free home for their child. In the event they cannot do so, their rights to their child subject to restriction and or termination. Thank you all for your time and your service. If nothing further, all parties are excused.
Thank you.
Kendall County, are there any objections?
No, Your Honor.
All right. With that, Mr. Dolzel, would you please begin the announcements?
Yes, John Dolzel for the department.
Jimmy Dresser, Patrol Investigation Supervisor.
Dustin Williams, CPS caseworker.
Lucinda Mance for the mother. She should be present, Judge. I am ready.
Jennifer Harris, attorney ad litem for the children. I'm ready.
For the record, I do have someone in the courtroom under a Samsung SM-A1 who is not able to unmute. It might be the mother. I'm not sure. However, Ms. Mance has announced already. So we'll go ahead and proceed and find that she has appeared. Okay, it is her. She can't unmute. All right. She just sent that in the chat. So mom is here. We're going to go ahead and move forward. you all are here for a court-ordered services case. This is not a TFF case, correct?
Correct.
All right. You all have an agreement?
Yes, Your Honor.
Okay. What are the terms and conditions of your agreement?
Well, it's agreed that mother will do services. I'm going to have Mr. Williams tell you what those services are. It's also agreed that the mother and the children will have no contact whatsoever with Thomas Crow, who was involved in the domestic violence with the mother.
Thomas Crow?
Thomas Crow, Crowe.
The first name is Thomas, though?
Yes, that's my understanding, Your Honor.
Okay. All right. Mr. Williams, what are the services that you want Ms. Rosales to complete?
Sorry, trying to unmute there. What we're looking for is participate in psychiatric evaluation, follow any recommendations on that, such as anger management, individual counseling, follow all recommendations for drug screening, drug alcohol assessment. If she is positive on any random drug screens, then I guess participate in the drug and alcohol assessment. I apologize.
Is that everything?
I believe so.
Ms. Mance, is that your understanding of the agreement?
It's my understanding we're also asking for counseling for the children. Is that correct?
Oh, yes. I'm sorry.
I have nothing further, Your Honor.
Okay. Is that your understanding of the agreement, Ms. Mance?
Yes, Judge. I reviewed all the services listed on the pleading, and I went over them with the mother. Additionally, the pleading references a safety plan, but I just wanted on the record that I clarified with Mr. Dolzel that there's no safety plan in effect. There's no safety plan that they're requesting. The request is just that the mother and the children have no contact with Mr. Crow.
All right,
and Judge, I would ask that if mother is in agreement, that she put that in the chat.
Okay. Okay, she says she agrees. Everybody can see it.
Yes, Judge.
All right. The wonders of technology. Okay, Ms. Harris.
The horrors of technology.
Or the horrors, too. It's okay, Ms. Rosales. I'm just glad that you're here and you're able to communicate with us. It's not orthodox, but when we don't have any other way to do it, it's better than nothing. Ms. Harris?
Your Honor, I wasn't consulted on the agreement, but I'm fine with that. I would just ask that the counseling does need to focus on domestic violence counseling as well as individual counseling.
Okay. I don't see any problem with that. All right. Then I think we've heard from everyone. Need to hear from Mr. Williams. You believe that this agreement's in the best interest of the children?
Yes, Your Honor.
And do you believe that the services are necessary to alleviate the effects of abuse or neglect that has occurred and to reduce the continuing danger to the physical health or safety of the children caused by an act or failure to act of the parent?
Yes, Your Honor.
And do you believe the services are necessary to reduce the substantial risk of abuse or neglect caused by an act or failure to act of the parent?
Yes, Your Honor.
Okay. Court shall find the same and order that these services take place. And Ms. Rosales, what this means is that under Chapter 264-203 of the Texas Family Code, this court is finding today that these services are necessary and in the best interest of you, or in the best interest of the children. And the services that are required, the court is ordering, are for both you, Ms. Rosales, and the children to have no contact with Thomas Crow, to participate in a psychiatric evaluation, that's just you, and follow any recommendations, including anger management, and counseling, which could be domestic violence and or individual counseling. Follow any and all recommendations for drug screening. And if there are any positive tests, then you agree to participate in a drug and alcohol assessment. And then for the children to have individual counseling as well. Court confirms there's no safety plan, just the no contact order. And then Ms. Rosales, if you have specific questions, you need to talk to Ms. Mance after the hearing so she can help you get with Mr. Williams and get the referrals that you need. Do you know, Ms. Mance, if your client has a job? Is she working?
Yes, Judge. She owns her own housekeeping business.
Okay. Ms. Rosales, if you could please answer in the chat. At this point in time, do you have funds available to you to pay for an attorney to represent you in this suit? All right. She just said that she, if you could see the chat, everybody should be able to see it. She cares for her fully immobile grandmother full time. I'm going to find that she's indigent for the purposes of this suit moving forward and maintain Ms. Mance as her counsel. Our compliance hearing is going to be June 5th, 2024 at 10:30. June 5th, 2024 at 10:30. And Ms. Rosales, at that hearing, I'm hopefully going to hear that you've made lots of progress and things are going really well so that we can move on down the road and try to close this case as soon as possible, okay? Mr. Dolezal, is there anything I have failed to address?
No, Your Honor, you haven't.
Okay, thank you all for your time and your service. Ms. Rosales, if there's some way you can get this Zoom thing figured out before our next hearing, I would sure appreciate it. All right, nothing further, all parties are excused.
Morning.
Thank you, Judge.
Thank you, Judge.
Morning. I believe I'm done for the.
Have you all conferred?
We have, Your Honor, although I've not talked directly with Ms. Fuller, and I think.
Yes, Your Honor, we have an agreement. The only thing Ms. Fuller is asking for BIP to be included, or victims class to be included. I would just ask that that only be part of the service plan if it's a recommendation of the mother's psychological evaluation. I think that's the only contested issue, though.
Well, and also that my client wants no contact with his mother at all, and they want it to be therapeutic, but he has asked that there no be.
Let me put y'all on pause just for a second because it sounds like we're getting into things that need to be on the record. So let me just call the case real quick and then we'll resume this discussion. Mr. Dolezal, would you please begin the announcements and if each party
John Dolezal for the department.
Jimmy Dresden Mitchell, investigation supervisor.
McElhaney, investigator for the department.
Kathleen Savage, attorney for the respondent mother, Juliana Moran. Miss Moran, if you'll unmute and announce your name for the record.
Okay, got it. I'm Juliana Moran.
Charles Weatherby, attorney for the alleged father, David Landreneau. I've been unable to find him, even with a background check. So I'm not ready, but not opposed.
Deborah Fuller, attorney ad litem for the child. Ready.
Marcus McLemore, Hill Country Casa. Reva, please announce. Oh,
sorry. Reva Johnson, Casa, guardian ad litem for the child.
And if we could just have 5 minutes, then I can just clarify if that's okay, Your Honor.
5 minutes in a breakout room with all the attorneys?
Yes, Your Honor.
Okay. All right. So do we have everything agreed or are we just asking the court to make that one decision?
We have like 98% of an agreement and we just need the court to rule on 2 requests from the ad litem.
Okay. Ms. Acevedo, I don't think you've announced yet. Could you announce for the record, please?
Sorry, Judge. Rochelle Acevedo for the father, Savas Cortez. I don't believe their service not ready, Your Honor.
All right. Do you know if we have service on either of the fathers? Mr. Dolezal?
I'm not sure, Your Honor. I apologize.
I can look it up, Judge.
I believe Mr. Savas is in Mexico, so I don't think so, and I don't know about the other father. I don't think they have contact information, so likely not.
I'm going to grant the not ready. I'm not going to make any orders as to the fathers today until we get some service on them. All right, what are the terms and conditions of the agreement?
And I'll be proffering those, Your Honor. So the terms of the agreement is an agreement to temporary managing conservatorship to the department, possessory conservatorship to the mother. Mother agrees to work the services of a psychological, individual counseling, and NAMI parenting classes. Belong agrees to set up individual counseling immediately for the child. Visitation shall be therapeutically recommended and with the consent of the child. Belong agrees to get a psychological evaluation set up for the child if he has not had one completed, or if they're not able to locate the one he has had completed. It's my understanding he's had one completed within the last 6 months, possibly. Belong shall obtain all of the child's MHDD records and provide it to all the parties. A specific order that Belong provide updates regarding the child's change of circumstances within 72 hours to the mother. And then the temporary order containing language that this agreement is not an admission of abuse or neglect. And that is the entire agreement, Your Honor.
What's the other 2%?
That would be my issue, Your Honor. Again, I want to apologize. They sent the agreement yesterday, and I did not have an opportunity until I spoke with Ms. Savage, probably at 9 o'clock last night. My issue is that I feel like the mother needs to do either a victims class or a BIP class, because the affidavit had a serious amount of domestic violence in it toward the child, and possibly domestic violence. And then also, my understanding is the mother's receiving funds for the child, and I would ask that those be redirected to the aunt who is the placement at this time.
And Your Honor, in regards to the victims course, we just ask that that be deferred to the mother's psychological evaluation, and obviously any recommendations made in that psychological she would comply with. We just didn't want to add more to the plate before necessary. And obviously we can't necessarily agree to the request on the money issue, but understand where the court might go with that one.
All right. So Ms. Acevedo, Mr. Weatherby really don't have any input in this particular agreement, so I'm going to skip over you. Casa? Ms. Johnson?
Sorry, I forgot I was muted. Apologies. I agree with Deborah's recommendations. Those all sound appropriate based on what I know to date.
Where's the department stand on that?
We're okay with everything, Your Honor, including Deborah's recommendations.
Okay. Ms. Moran, you've had the opportunity to discuss this agreement with Ms. Savage, your counsel?
Yes.
You understand the agreement?
Yes.
Did you enter into it voluntarily?
Yes.
Were you forced in any way to agree to it, or made any promises to get you to agree to it?
No.
And are you asking the court to approve the agreed parts of the agreement?
Yes.
Okay. You understand what's expected of you?
Yes.
Okay. Court will take judicial notice that mom was served on April 10th, 2024 by personal service. And the court takes judicial notice that neither Mr. Cabello or Mr. Landrino have been served yet. Grants Ms. Acevedo's not ready. Mr. Weatherby not opposed moving forward, but because his client hasn't been served, I'm not going to make any orders as to either father today. For the purposes of the adversary, before we make a ruling, Ms. Peterman, is everything that was in your initial affidavit still, as far as your knowledge, true and correct?
Your Honor, that would actually be Investigator Kara McElhenney that completed the affidavit.
My apologies. Ms. McElhenney, to your knowledge, is everything that was in your affidavit still true and correct?
Yes, sir.
All right. And you believe that these orders are in the best interest of the child at this time?
Yes, sir.
All right. Thank you. Do the parties stipulate as to the reasonable efforts made by the department in this case?
Yes, Your Honor.
Yes, Your Honor.
Court finds that there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the child's removal, and reasonable efforts have been made to enable the child to return home, but there's a substantial risk of continuing danger if the child is returned home. Court adopts and approves the agreement of the parties and will order that the Department of Family Protective Services / Belong be the temporary managing conservator of the child, Tristan Moran. Mom, Juliana Moran, will be the possessory conservator of the child, temporary possessory conservator. And Miss Moran agrees to following services of psychiatric, was it psychiatric or psychological?
Psychological, Your Honor.
A psychological evaluation, individual counseling, NAMI parenting classes. Belong agrees to provide individual counseling for the child. There's a therapeutic recommendation visitation requirement. So visitation between the child and Ms. Moran will be based on therapist recommendation, and the child's consent. The child shall have a psychological evaluation if he has not recently had one, and or the results of the recent one, if it exists, cannot be located. Belong is also ordered to obtain and provide all of the child's MHDD records to all of the parties. Belong is ordered to update the parties with any change in the child's circumstances within 72 hours to the mother. Part of this agreement is that pursuant to Chapter 262.013, mom is not making any admissions of abuse or neglect due to her agreement to the voluntary managing conservatorship of the department. Court will order that any funds for the child being paid to the mother be immediately redirected to the aunt, who is also placement. Ms. McElhenney, is that placement safe and appropriate in meeting Tristan's needs at this time?
It is, Your Honor.
Thank you. Regarding the disagreement on the domestic violence issue, a lot of times in our cases where we have domestic violence at the outset, it's ordered. It sounds like there's no, I understand that Ms. Moran is not admitting to what's in the allegations in the affidavit, but it doesn't sound like there's a dispute that these things did occur to some extent, which in my opinion is enough to warrant ordering these things rather than waiting to see if they're recommended. So I'm going to order that Ms. Moran have some domestic violence intervention. I don't think we need to do BIP. I think BIP is probably more than we need to do at this point, unless, of course, there's a recommendation for it based on her psych eval. So my order on this is going to be that Ms. Moran needs to do a victims class. And then if her psych eval recommends a BIP class, she's ordered to do a BIP class. I want her to have something. I just don't know that we need to go all the way to BIP unless somebody with more letters behind their name says than I do, says we need to. Our next hearing is going to be our status hearing, June the 5th, 2024 at 11:30. June 5th, 2024 at 11:30.
Your Honor, I just wanted to update the court on the young man.
Okay.
I mean, I saw him on Saturday. He's very happy where he's at. I mean, he's healthy looking. He's very well taken care of. The aunt is on top of all of his needs. He, I guess, recently was in the hospital in March, so there should be a psych eval You know, he's on medication, so I know that they switch over to Superior Health, but he's was very happy where he was at, and he was very healthy looking, and the aunt is taking care of him. So I think it's a good placement for him. I guess she raised his sister from the time she was 15, and now she's in college. So she's ready to take on Tristan.
Okay, very good. I kind of surmised that you were good with things as well, Miss Johnson, but do you want to add anything as Miss Fuller did?
Apologies, I have not had a chance to meet with Tristan yet, so I'm really not in a position to add anything.
Okay. I have to admonish you, Ms. Moran, the state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. In the event you cannot do so, your rights to your child are subject to restriction, as they are now, or termination. Mr. Dolezal, is there anything I failed to address?
No, Your Honor.
Okay. Thank you all for your time and your service. Yes.
And the mother did file an affidavit of inability or to afford court costs. I just wanted to see, or an affidavit of indigency, I should say, if the court will continue me in her an appointment and find my client indigent.
Thank you for bringing that up. I do need to go over that briefly with her. Ms. Moran, do you have the ability at this point in time to pay for an attorney privately?
No.
Do you have any funds and savings that you could liquidate to use to pay for an attorney?
No.
Do you have any assets that you could sell that you could use to pay for an attorney?
No.
Are you receiving governmental assistance?
I just get food stamps. That's it.
I'll maintain her indigency status for the purposes of this case. I can't make any determinations as to Mr. Cabello or Mr. Londrino, so obviously Ms. Acevedo and Mr. Weatherby will remain on as well. Thank you for your time and your service. All parties are excused, and I'll see some of you after lunch.
Thank you, Your Honor.
Your Honor.